State of Arizona Division 2 is now in session.
Good afternoon, everyone. Please have a seat. This is the time and the place for oral argument in the matter of Arrett and Lamonna versus Bauer. This is our file number 2CACV 2015-0017. If council could please announce.
Yes, Bill Reisner for the appellants, Judge.
Patricia Ronan, accompanied by Tobin Seidels. I'm with the law firm of excuse me.
You can do it.
Curtis, Goodwin, Sullivan, Udall, and Schwab.
Thank you, Ms. Roman.
And I'm the Oro Valley Legal Services Director.
Jim Driscoll McCaffrey on behalf of the Secretary of State, Michelle Reagan. And with me is Eric Spencer, the State Election Director.
Thank you. I understand that counsel for Ms. Bauer and for the Secretary have had an opportunity to divide their time. Is that true?
Yes, Your Honor, that is true. We have agreed that counsel for Ms. Bauer will present to the court for 18 minutes, if that is agreeable, and reserve the remainder 7 minutes of the 25 for the intervener state.
Thank you. Mr. Reisner? It's your opportunity. Thank you.
Yeah, thank you, Judge.
Mr. Reisner, I have an initial question for you about the parties, so I want to make sure that we have our names correct. Ms. Arrett and Ms. Lamonna were both named as plaintiffs in the underlying action and are here. Ms. Arrett is the lead name, at least, insofar as how this expedited election is pled. However, I'm wondering initially, is Ms. Arrett really in the same position as Ms. Lamonna? What is her status, since I understand that she's not raising the same arguments that Ms. Lamonna may be arguing in terms of the applicability of the statute pertaining to serial numbers?
No, they are both in the same position because there's nothing in front of this court relating to that second petition. There wasn't enough signature, there's nothing about it. So the statute that permits people to sue really says that any citizen can do it, any person can do it. It happens that they both signed the referendum, and so they both are in the same position as signer. Ms. Lamonna certainly has an additional role and testified in court because she's the one who came in and set up the committee and took it out. But they both have the same standing and are raising identical issues, Judge.
But only with respect to the petition that was issued in 2014.
Absolutely.
Okay. Thank you. I think you've
Yeah,
clarified
thanks,
that.
I'm sorry. Yeah. May it please the court. I think there's three key aspects to the case. First, 19-111 explicitly does not, and expressly doesn't provide that referendum petitions are void if they do not contain the correct serial number. And I think that's an issue that this court dealt with in Force versus Rodriguez and A.R.S. versus City of Bisbee. The second key aspect is the rather unique and unquestioned importance of referendum and initiative and recall, but certainly referendum in our Constitution, in the framing of the Constitution, and in the history of Arizona. I mean, it's just everybody that's looked at it, everybody every case, everybody understands that that is a key thing in our Constitution. I asserted that I think originally it was the only part of the Constitution. I'm not certain about that, but I think so, that it was the only part that had that it was self-executing. It went on for pages. It had details. So that certainly is a huge background. It's not challenged, but it's important and worth speaking about.
Mr. Reisner,
Uh,
if we grant the relief that you're requesting in this direct appeal, can you envision any circumstance where a petitioner that doesn't put the serial number on the petition would not be entitled to the kind of relief that you're asking for? In other words, doesn't the relief you're requesting simply invalidate the statutory requirement of this serial number being placed on the petition?
Well, I suppose it depends on how you would view that statutory requirement, whether it's, I pointed out, I think really the shall is directory in that situation, and it's not mandatory, and that the legislature, simply is powerless to say that everybody loses everywhere. But I do think the focus really should be on the town of Oro Valley. We're looking at the petition for these people in that town. And I think a ruling from this court would relate to that situation and not necessarily say anybody, anywhere, anytime. Although, I will candidly say the reasons that I've seen and given for this, I'm not sure where that would or ought to eliminate the requirement. If 300,000 people sign something and it goes up to Phoenix, to the Secretary of State, yeah, I think it would be wrong to apply that. I don't think our legislature can make those kind of rules. And then we have to look at the overall thing. Clearly, the legislature doesn't like referendums. I mean, it challenges them. Clearly, they can set up rules. And I think we have to look and say, okay, what's the purpose of the rules? And I cite case after case where they drill down and say, what's the purpose? And then courts will say, well, this purpose may mean that people need to have an explanation of what it is. This one requires that the people who sign up or be voters and so forth. There are requirements that make sense, that relate to the heart of what a referendum is.
So what you're really saying is that to the extent the legislature adds to the constitutional provisions so as to facilitate the referendum process, it's entitled to do so, but it's not entitled to make the referendum process burdensome or obstruct that process in its additional rules.
That's exactly what I would have said if I
So that
said it as well.
leads me to my question,
Okay.
which is, could you describe your argument as to why you think the filing number rule is, I gather your argument is it's more of an obstructive rule than a facilitating rule, and maybe you could describe why.
Well, I don't even know with, Oro Valley, it's almost meaningless, really. You look at it, and I think I pointed out, any number, if, like, the R1466, that my client thought, when she looked at it, seemed to be, and it just says number, that seemed to be a logical number. So whatever purpose that would have for the clerk's office, that would serve as good as any other number. So I don't think anything about a serial number for court, for a clerk's office that hadn't had one in 4 years. Anything about that says there's meat there that's important enough to defeat this important right of thousands of people in this community for their right to referendum that they didn't give up. I don't see it.
Mr. Risner, let me ask you a question.
Yeah.
Given what you were just talking about, and it looks like it could be kind of burdensome, I don't know that I would necessarily disagree, but wasn't your client given some specific instructions on placing the serial number, and at least that it was important to the clerk, if nobody else?
No, I don't think she was given, it depends what you mean by instructions. She wasn't told anything about that. It's true that she was handed something that said serial number in there. It's true that she was handed it. It's true that she was cited to the Secretary of State's manual. That Secretary of State's manual said, hey, this is for the statewide, and check with your local office to see if they have any other rules. she checked with a local office. But if you look at what she did receive and from the clerk's office, the number that the RF 1401 is listed as the committee's number. The thing she got, it says, what's your committee number? Okay, so that's the committee registered, that's our number. And then when it came down to the petition itself, it says number. So you say, oh, well, let's see, we have to, we're attaching this R, 1466, which was the resolution, so that must be the appropriate number. That's how it came about. So to say that it was explained to her, yeah, she was handed something just like you might get boilerplate somewhere else. But I think the question you have to look at is if the town's right, there's no doubt that this defeats this employee. That's what they say is the consequence. And what's that used for? The clerk said, well, if I got more than one end at the same time, we'd have something to use it for. But I say in my brief, the statute as to what the clerk goes through when you bring these things in. When you bring them in, they get them all together. They go along and say how many are filled here, and they put a number on top. This petition is 15. This one's 13. They Xerox them. There's a whole process there.
So is
That
it your
number is-
position that the serial number business is kind of discretionary with the clerk?
Yeah, I would say, I've made the argument that absolutely that it's directory. If the clerk rejected it as she did, then at least the court and the Superior Court should be able to see and look at the Arizona law and apply the case law and the Constitution and say, wait a minute, the purpose of this requirement is for, may have some benefit. It's really small. I don't actually know what the benefit to the clerk's office is, but it's certainly nothing that would override the right to referendum. I went through in my brief every argument that they used as to why this thing is useful. But petitions, if you look at, boy, they all write out things. Here's what the key deals are. Here's this. You make sure that everybody's a voter, that they swear that they filled things out in your purpose. There's everything there that is related to the key of a referendum, which is, what is it that you're referring? Do you understand what the key things are? And read more if you want to know more. And are you a voter, and where do you live, and fill it in, and are these good signatures? Those are rules for the people to exercise their right to referendum. And to me, it's monstrous to say, and a violation of basic rules of our democracy and the way our Constitution is set up, to say, oh, well, when it said number, we meant the serial number, and that was not the number where we said that it was your committee number, and it's not the resolution that's in the series, it was this other number, and aha, all you 3,160 people lose.
Mr. Arrett, that seems to be your facial challenge. And that's part of where I was asking about is, in your reply brief, you're pretty clear, oh, we're just making it an as-applied challenge.
Yeah.
But almost all of your arguments are what you would expect for someone who is challenging the entire law. You've addressed each one of the potential purposes of the statute and said that's meaningless or it's invalid. So that's more of a facial challenge. And for us, it's important that we be able to differentiate between it as an applied and as a facial challenge. That's what I'm trying to get at. Do you even have some situation in mind where it could possibly be valid, but just not this one?
You know, of course, I'm making this argument because I want to win, and I don't know if you'll go with the broader picture or not. But yeah, can I think? No, I can't think of any. The Attorney General helpfully had a list of the referendum that went up to the Secretary of State's office. There aren't many of these things. And when they're turned in, people come in with boxes of them. They turn them in at the same time.
As long as you're addressing that argument of how could apply on
Yeah.
a statewide basis, there's also the added issue of, this isn't just an issue with respect to referendum, it's also an issue with respect to initiatives. So there are considerably more initiatives, at least historically. And then there's the added issue of probably initiative are more likely to be amended, and there could be multiple versions of an initiative. And at that point, although they may have similar language, it's not identical language. Whereas generally, I think referendum, you have the same issue coming up. So is this something where you're asking for us to declare the law unconstitutional just with respect to referendum, but it's otherwise valid with respect to initiative?
Well, I think it's a referendum where it matters, because the rules until the court started going with a different slogan related to initiatives is substantial compliance. And it's true, I can't imagine anyone coming in and saying there's not substantial compliance. So really, the initiative situation's different. I don't think you couldn't dream of knocking out an initiative because they had a different number. And I sort of suspect that the reason it hasn't come up is the Secretary of State's office may do a better job. It's a thing where it's checked out a little better. My client, as you may have seen from the record, did two lawyers look at her petition. There was a real effort on the part of the appellants to see that they got everything right, and it's the number thing was all that was wrong. So I think this.
You've reserved some time.
Yeah. So unless you've got more,
Okay, we'll see you again.
okay. Thank you.
Ms. Roman?
May it please the court, both sides are here purporting to protect the fundamental right of the referendum. And the position of the committee, which is supporting Ms. Arrett and Ms. Lamonna in this appeal, is that they had enough signatures that holding them to the serial number requirement is undermining and obstructing their right to a referendum. And so those of us who want to require that the 60 years of law in which the serial number has been part of Arizona statutes be preserved, and the 40 years of precedent in which strict compliance has been the standard that this court has held referendum petitions to be complied with, and that this appeal be denied because that's the way to protect referendum rights. We don't think that those 3,160 signers understand what's at stake by taking away the serial number requirement. Those who brought this petition followed every requirement but one. And that requirement was not an obstacle to their right. It did not impede their right to participate in the referendum process. They were issued a serial number, as they must be by the clerk when they made the application for a serial number. They were advised that that serial number should go on the petition.
Okay, let me stop you right there, because Mr. Risner just said nobody was advised. It's buried in some, maybe to put it under his view, some fine print in a manual that somebody tossed to her.
I'd like to address that argument, and it is addressed also in our brief at page 7, paragraph 11. First, it is clearly stated in the statute that Ms. Lamonna said that she read. It is in 19-111B, in which it clearly says that the serial number must be placed on the right-hand lower corner of each page of the petition. Secondly, it is on the application for the serial number which Ms. Lamonna signed. It says that the petition serial number must be filled out. That is in the trial record, and it is cited in our brief. It is in the Arizona Secretary of State handbook, which Ms. Lamonna received in the form of a link prior to even applying for the petition serial number before the resolution at issue here was even passed. She also received the Arizona Secretary of State handbook in hard copy form from the clerk and on a hard drive. That handbook has in approximately 6 different places instructions about including the petition serial number on every page. It has diagrams about how to do it. In the trial transcript, I went through that with the clerk, Julie Bauer, that shows exactly where, and it also expressly says the consequences of not including the petition serial number on each page are that those pages shall be excluded, and that is required by 121.01A1C.
If it's so clear, though, sounds pretty clear, how is it that the two plaintiffs, and you agree that it doesn't matter whose name is on this appeal, I take it?
Sure.
So, we have 2 plaintiffs who don't understand that, and apparently at least 2 lawyers that miss this whole thing. If it's so clear, how are all these people not perceiving it, and does that at least lend itself to the argument that this is kind of an obscure, ticky-tacky thing that's burdensome to the right of referendum?
Thank you for asking that question. I think that that's very important, and I think the factual record addresses it very clearly. First, Ms. Lamona's testimony is that she did not specifically address this question to the attorneys. The attorneys had no background in election law and perhaps did not look into this issue. Secondly, Ms. Lamonna was very focused on the case of Forrest v. Rodriguez, which was an Oro Valley referendum case. That case dealt with whether or not the referendum, which had been attached to the petition when it was circulated among the voters and was a valid petition up until the point it was submitted to the town clerk, should be referred for purposes of a referendum when the when the resolution itself had been removed just prior to submission to the clerk, when 19-121.01 requires that the resolution remain attached to the petition at the point it is submitted to the clerk. When it's submitted to the clerk then removes it. And so in that case, the petition had been valid all the way up until that very moment. They took it off, handed it to the clerk, and the clerk, very strictly construing the statute, refused the petition in the litigation because there was no evidence suggesting that there was any point in which the petition was not valid. The court found that it was not appropriate to find that the statute required disqualification of the valid petition in that case. So Ms. Lamonna knew that the resolution and the resolution and including the resolution was very important because of her understanding and memory of that case concerning Oro Valley. And that is reflected in her trial testimony. That is why she thought it was important to put the resolution number in that blank, and that is what she did. She made a deliberate choice to do that.
Do you think that the omission of the serial number affected the validity of any of the signatures?
In this case, no. But that's not the question before the court. The question before the court is whether or not to continue to apply strict compliance and to continue to guide clerks in towns and the Secretary of State to strictly apply the statutes that the legislature has written. And those statutes have a purpose, which I would be happy to address if you'd like to hear that. But
Well, since you've already quoted Forrest, there is that dicta, at least, in Forrest that says proponents' failure to strictly comply with the procedural statutory requirement doesn't always necessitate that the referendum petition be declared void. Now, how do we deal with that in this circumstance?
I think that both Forrest and Harris v. Bisbee, which appellants rely on, demonstrate an exceptional situation in which there is a preponderance of presumption. That preponderance can be lost and then regained. That's where the petition remains valid throughout. That's not the case here. The petitions here were never valid because the requirements of 101B require that the petition serial number be on from the very beginning, and that's why the petition has the instruction that no signature shall be gathered until a serial number is issued. There's an entire statutory scheme at work in which the serial number is critical to preserving the validity and ensuring that there is no fraud in the petition process. While we do not have an issue with fraud here, if we are suddenly tinkering with whether or not there is fraud in this case, not fraud in this case, do we ignore the requirement in this case and not in that case, then how are we preserving the principle of uniformity that is so vital to maintaining the right of a referendum?
Is the answer that the petitioner loses the presumption, but then can regain it by going into the trial court and essentially having an evidentiary hearing?
I think in this case that's impossible. First of all, the presumption would have to be cured within the 30-day period, and the 30-day period had run. Secondly, in order to cure it evidentiarily, there would have to be evidence that the petition corresponded with the serial number and that there was no fraud in connection. And although we didn't have an issue with developing that because it wasn't before the court and wasn't the issue before the court, we would have to essentially get testimony from 3,160 signatories about what they knew about the petition, why they signed it, whether they thought it was a valid petition, and whether this petition corresponded with the petition to which the serial number was issued. That's an unwieldy administrative and judicial burden that I don't think is appropriate under the context. That's why we have a bright line rule.
If you just took out of the equation, what difference would it make if the serial number was on it versus not on it?
The difference it makes is that the legislature has required it. And the reason the legislature has required it and established the statutory scheme, which starts with 19101B, continues with 19111B, goes on to 19121, and then finally concludes with 19121.01, which requires that pages of the petition that do not have the serial number on them must be pulled. The entire page, all 15 signatures are presumably invalid and cannot be reviewed or passed on in any way. That entire statutory scheme, if that requirement is ignored, becomes invalid. And it is not one statute, but it is that scheme. And that's why considering the shall in 119B does not make sense as directory, as merely being directory, but must be mandatory and compulsory because the statutory scheme works together. The purpose of this statute is not merely to ensure that there is an administrative ease with which petitions may be processed. It is also to protect voters. For example, if a petition had no serial number, then how could a voter be sure that the person collecting signatures had any intention of submitting it for a legitimate political process? It could instead be part of a criminal enterprise in which a person simply wanted to know the activities and the adults of their neighbors living nearby, could ascertain how many people over 18 lived in a specific residence, and then scout that residence to burglarize it because they have signatures on a petition. Otherwise, rivals in a hotly contested political issue could bring a false petition in order to thwart the efforts of legitimate petition bringers and collect signatures, feigning the effort to collect signatures on a legitimate petition with a real signature, with a real serial number that will be turned in to the Secretary of State or the clerk. And the numbers may not be gathered on a real petition because there's no serial number to check. And the serial number allows those who want to confirm the legitimacy of the petition to call into the clerk or the Secretary of State and say, did someone register that serial number? Is that a real petition? Who's bringing that petition? How can I check that? That's
Let me
the
ask
process.
you something, and this may not, this may be besides the point, but do you know if anyone's ever done that? When they've had a petition presented to them? Hang on, I'm gonna call the Secretary of State or the clerk, and I'm gonna confirm the serial number.
I do not have that information.
Okay, just doesn't seem very likely.
I think it's important that voters have that option, that voters have a mechanism by which to protect themselves, and that by registering serial numbers, those who bring forth petitions are held accountable. And that's what the registering of the petitions and the serial numbers do. And that's something that's very important to protecting the referendum process. And the simple act of getting a serial number and writing it on a page does not in any way impede. It does not hinder the access of voters to information. It does not burden any more than 8-point font burdens or 100 words to describe the purpose of the referendum. And to interpret the language of this statute strictly is no more difficult than the finding of the court in the case of Committee for Preservation of Established Neighborhoods versus Raphael, in which the court found that insert, with regards to the description of the purpose of the petition, did not mean attached, but literally meant place on the petition.
Can there come a point where the legislature requires so many technical things that it becomes that a significant percentage of referendums are winnowed out simply because people haven't gone to the right lawyer whose expertise is high enough in the area?
That may be the case, but I do not think that it is the case with regards to the serial number requirement. And I think that you, Judge Eckerson, have noted that the requirements can be difficult. In the case of Fidelity Mutual versus Town of Marana, you noted that even the most obvious, seemingly obvious requirement of the statutes, without the specialized advice of an attorney, could sometimes be a burden to those bringing referendum petitions. But nonetheless, the 30-day requirement there, which is much more difficult, was strictly applied. And the 30-day requirement is a lot harder to figure out than the bright line rule of putting the serial numbers in the lower right-hand corner when the petition says it at the top, the petition serial number application says it, and numerous other instructions, and the clerk even says to you when you fill out the application that you have to put the serial number on it.
Which case was that again? Judge Eckerstrom on?
It was Fidelity Mutual versus Town of Marana. Am I right?
Sounds right to me.
We may need to
I've
make
authored
sure.
a lot of cases through the years. If you say authored it, I trust you.
We may need to
You
make
just
sure. we
concurred
got
on
it right.
forced. You just concurred on forced, so. But I think the important thing here is the legislature has the authority to pass these laws. And the legislature has discretion to decide what are the best ways to supplement the constitutional right. Our purpose to review this is not whether they had enough signatures, whether enough people cared about it, but did it really obstruct the fundamental right? And they made a decision and a mistake, both of which were deliberate. They had enough access, not because the law was difficult, not because they didn't know how to follow the law, but because they chose not to. Because they set up their priorities in such a way that they ignored it. It's almost like a college applicant showing up for the SAT without a number 2 pencil and then being frustrated because all of their right scores aren't graded. Then how can they be? They didn't use a number 2 pencil. And you don't blame the test grader for that. You don't blame the clerk. The clerk shouldn't have to decide whether the 8-point font matters or whether the serial number matters. We don't want clerks making that decision. We want the standards applied uniformly. And that's another fundamental principle that comes from the Town of Marana decision.
Let me ask you this. If we were here applying a substantial compliance standard instead of a strict compliance standard, do you think they have substantially complied?
Yes, they have substantially complied. But the standards have to be different and are consistently held to be different for initiative versus referendum. Initiative is a much more broad and open process. It's where we want the people to create the law. A referendum is a veto process. It's a very narrow and constricted thing. Once the law has been passed by the representatives of the people who have been elected by the majority, once it's gone through the open process, this is a resolution that was subject to public discussion. It happened in an open meeting, and then it had 30 days before it could go into effect. That's exactly what happened here. The process worked. What didn't work was part of their participation in the referendum, because they didn't add the serial number. But their participation in the referendum process worked. They're just not entitled to have their issue on the ballot because they didn't follow the rules. Did they substantially comply? Sure. But being fast doesn't mean you get a gold medal at the Olympics. You have to win. And that's what it means for a referendum. And that's what we want it to mean. Because vetoes are very serious things. And the expensive bringing a veto to the people is a very serious thing.
Ms. Warren, are you aware of any other cases in which this serial number issue has arisen?
No, there is no other case in which serial numbers have been litigated. There is one case in which there was a challenge to and I apologize because I do not recall the site off the top of my head. I can supplement later if you wish. But there was a challenge to the Charter of Tucson's provisions concerning whether or not it conflicted with state statutes, and the city of Tucson's charter allowed both the serial number or allowed either the serial number or the referendum number on the petition, and it was found not to conflict with state statute. But that's the only case that dealt with it, and that was not the issue. It was a footnote in the case. It was not the issue of the case. So no, this is not something obviously that people are having much trouble complying with. And I'd like to urge the court to understand, this is not a case about Oro Valley. These are requirements that apply to everyone. And it's important to remember that if this statute is found not to apply in Oro Valley, then it will also not apply to everyone. The clerks will no longer have the guidance of what to do when something substantially complies. How much is substantial? Which parts do they count and which don't they? That's why strict compliance is so important. It's the guidance that we need. It's the uniformity, and it is the fairness that is fundamental to protecting this right.
Ms. Roman, before you sit down, during the scheduling conference for this, we discussed when this decision would have to issue in order to provide sufficient time for the Supreme Court if one or more of the parties wanted review. Has that changed at all? Are we still on a schedule essentially the middle of March? Is somewhere between the middle of March and the end of the month?
Yes, Your Honor.
Thank you. Mr. Driscoll, the captain?
Thank you, Your Honor, and may it please the court. Counsel for the town clerk has presented a number of compelling reasons why this appeal should be denied. The Secretary of State has intervened in this matter to emphasize the importance of the petition serial number requirement and to provide context that was missing from the opening brief in this matter. The petition serial number requirement serves a core function, preserving the integrity of the referendum, initiative, and recall process. This is not a mere procedural matter that has, as I believe the appellant characterized it, an imaginary value. The state's interest is precisely aligned with the people in this matter. It's to ensure the integrity of the process. Throughout the scope of Title 19, the legislature has made sure that this serial number is present from the very beginning of the process to the very end. It provides a check to make sure that the petitions that voters sign to exercise their right of referendum or initiative are authentic, and make sure that they are signing their name to something that they agree to, and that if that changes later in the process, that their signatures are not counted to something that they do not agree to.
How does the serial number help an individual signator know that this is all related? Because, you know, generally most of the statute is oriented at making sure that there's a brief description that you can look at, and that the rest of the referendum is contained within it, if you want to read in more detail. It's still not clear how the serial number helps somebody make a decision whether they should sign or not.
It doesn't go to the question of whether they should sign based on the substance, but it goes to the question of whether or not it's a legitimate exercise of the right of referendum or initiative. Which is to say, as counsel for the town clerk has said, that this is an actual petition. Just last year, in 2014, the legislature amended Title 19 to make sure that at the top of every petition page, there's a statement that says it is unlawful to sign a petition before it has a serial number. That's just the most recent emphasis on the fact that voters should know that if a petition does not have a serial number, it may not be valid. The serial number also makes sure that the petition is attached to a political committee or a campaign finance number. It provides these signposts of authenticity. It is possible, and indeed there are a number of requirements that perhaps every voter does not go and check every single thing, but it provides a tool so that if a voter does have a question, if a voter has a reason to doubt the authenticity of an initiative or a referendum petition, that they can go to the Secretary of State's office, they can go to the filing officer and say, I got this petition, it had this number on it, is this real? It provides a tool. It's not to say that this is something that a voter will use in every instance, but the legislature, as the legislative history makes clear, saw a pattern of abuse in the initiative and referendum process, and then it said that it had fallen into disrepute. And it was important to provide checks to make sure that people could trust that their rights were being exercised legitimately and not being taken advantage of. The serial number was one of the tools that the legislature chose to effect those changes.
Was that admonition present on these petitions?
I don't have the petition before me, but if it was in 2014, I believe it was, but I'd have to check and I'd be happy to supplement.
No, that's fine. Since you had mentioned it, I thought you don't recall that coming up.
I also think it's important to emphasize that the standard here is that the legislature may reasonably supplement the Constitution. It's not whether or not the legislature has chosen the best and most powerful tool. They've chosen a good tool, but the precedents established that the standard is when looking to if whether or not it is reasonably supplementing the Constitution, we look to see if it's inconsistent with the Constitution. And the appellant has simply made no showing that the petition signature requirement is inconsistent with anything in the Constitution. It is true that we have bad facts here in the sense that it is deeply unfortunate that the circulators for this petition failed to put the serial number on every single page of the petitions they gathered. But bad facts make bad law. Here, the standard is well set that strict compliance applies, and there's no question whether that the petition serial number conflicts with anything in the Constitution. It does not. If anything, as I've said, it persisted, the legislature has maintained over the course of years that this is a tool that can be used to ensure the integrity of the process. This is not something where the state is trying to shift the burden, to shift power from the people to the state, as is the case in the Dobson decision where the Supreme Court was discussing. This is not the case where the legislature sought to restrict the time that was available to gather referendums. Far from it. It is made very clear that you get the serial number at the very moment that you apply to begin the petition process. As counsel for the town clerk said, the handbook that is supplied says over and over again in quite large print that the serial number needs to go in the bottom right-hand corner of each page. The argument that because in this instance the requirement was not followed, thus means that it should not be applied, would theoretically apply to every requirement the legislature has set forth with regard to petition. Because it is unfortunate whenever that right is being exercised in a way that does not comply with the statutes. For example, in the rifle decision that counsel mentioned, there the text of the description for the referendum was not on the petition as is required by statute, but it was attached to it by staple. Nevertheless, the court found that that did not comply with the statutory requirements and was thus invalid.
Counsel, how would you differentiate Forrest versus Rodriguez and A.R.S versus City of Bisbee?
In Forrest, Your Honor, the petitions were valid when signed. They had all the requirements throughout the process. It appears from the court's opinion that the attachments were simply removed before they were turned in. The court appropriately looked to see, okay, that destroys the presumption of validity, but we can look back and see that the information was available to the voter. Here, then, the information was never available to the voter. Similarly, in Harris, the city had excluded entire sheets based on the inclusion of individual invalid signatures. That is not the case here. Here, each petition was invalid in its entirety. As the legislature made clear in section 19-121.01, where it instructs the secretary and by correspondence the filing officers to remove all sheets that do not have the serial number in the bottom right-hand corner. That is not discretionary. It's the first step in the process of tabulating the number of signatures. That shows how important this requirement is to the legislature, and it's something that is regularly enforced by the Secretary's office and by filing officers across the state.
Let me ask you this, would it necessarily, though, do great damage to the statutory scheme to permit, say, the clerks some leeway, some discretion, and in other words, allow substantial compliance in a case like this where the voters don't necessarily rely on the serial number, and sure, it's a requirement, but at least, you know, there is an argument that it's extremely burdensome when someone thinks they've done it all right, they come in and they're just blown out because of this one little technical detail that they overlooked.
Your Honor, with respect, I do think that this is more important than just a technical detail. It is the key identifier for these petitions. I'd also make clear that the Supreme Court and multiple panels of this court have said over and over again that strict compliance with constitutional and statutory requirements is the standard for referendum petitions. So I don't think that this court has the power to change the standard to substantial compliance standard.
Would we have to do that here in order to rule in the appellant's favor?
Your Honor, I believe you would. I think if you look at the decision in Lawrence, the court attempted to reconcile the respect to the power of referendum with the strict compliance standard by employing the two-step process. It first said that you have to strictly comply with the language of the statute. It then, in order to effectuate the broad purpose of the power of referendum, looked to see if there's any ambiguity in the statute. Here, there's simply no ambiguity in the language of Title 19. The serial number issued by the Secretary of State is not any other number. It can't be just any number in a series. It is a very specific number, and committees and individuals gathering petitions for decades have understood what that serial number is.
I think you're at the end of your
Oh,
time.
I apologize. Thank you very much.
Unless the colleagues have any questions? I guess not. Thank you.
Thank you.
Mr. Reisner, reply?
Yes. Thank you. You know, the argument of Oro Valley was that simply because the legislature required it, that needs to be done. But, you know, the cases, the ones that were just referred to, Lawrence v. Jones case says the statutory construction, they say that first of all, you look at why in the first place did the legislature do it. The Force case talked about, and again quoting direct sellers versus McBrayer, it's, the question isn't that is the legislator supplementing something that wasn't in the Constitution or not prohibited. What they have to supplement is the constitutional purpose. What they have to supplement is the ability of the people to exercise their right of referendum. That's what the legislature can do. They can't create rules just because they think it's a good idea or they want to do it. You actually have to look at the rule and say, look, the legislature has limited power in this area. That's it. The people did not give them the power to do anything about referendum except to assist and supplement the people in the exercise of the people's power.
Do you disagree, though, that some, if not this regulation, some regulation is necessary and permitted?
Sure.
In the area of referendums?
Sure. For instance,
And one other question to go with that, do you disagree that, as has been argued here, that this specific serial number requirement is an important tool in terms of the integrity of the whole process on a statewide basis?
not at all. That
No.
is absolutely invented. Look, it's difficult for people to go out and get signatures on a referendum. And so they fantasize. They fantasize that, wow, maybe, you know, there's criminals that want to know people's names. Well, heck, they can go to the where people register to vote and get everybody at that, you know, at these different addresses. These are, it's not reality in the real world. But the people who get signatures are going out, and these people are making sure that the people say, yes, I'm a voter. Okay, well, you're a voter, and you write in your address, and you put the date, and you put your signature, and that signature is checked. That's reality. You know, somebody sat in a room and said, wow, is it possible that we can come up with some reason that maybe relates to anything other than usefulness in the clerk's office? I don't know, but it certainly isn't there in Oro Valley. There's none of that. You know, there was discussion about the Miranda case, and she, used the term bright line rule. That's really a fairly, good example, because there is a real question and there have been a bunch of cases on whether in a zoning matter, when do you do the referendum? For instance, in this case, we have a resolution that says the city can buy this thing, and then later on, there'll be a contract and they come up, and so someone might say, gee, when do you referend? Do we referend to the deal later or now? There are a bunch of cases like that. So our legislation, I think it came from the Shirley case, so look, we're gonna have a bright line rule. That's when you do it. Okay, that bright line rule made sense. It related to something that the courts felt was a problem, and so they said, okay, you don't do that one right, you lose. But all these rules have to be related to assisting the people in their right to a referendum. And all we can hear, every one of these is supposed reasons, the supposed importance. The Secretary of State who in argument says this thing's really important, put the details, and in his brief he says a critical important thing is these amendments. And yet you could see if you look down, I think it's one referendum was amended somewhere. And I'll bet you they can't find anywhere in history in Arizona, anywhere, where somebody has come in and said they faked a referendum to get some signatures. I mean, that person could fake the number too. What's the problem? Clearly, if they're doing that, they'll fake that number there. But look,
Mr. Rogers, how do we draw that line of where something is more important for preventing fraud? So for instance, I'm thinking as you're arguing, well, we have these requirements with respect to notaries, that you have to have a certain verification process at the time.
yeah,
That doesn't really necessarily help the people decide whether or not they want to sign a petition to have a matter referred to the people. It's more designed to ensure that those who have signed are legitimate electors within the appropriate geographical location. So it does seem that our law allows some leeway for preventing the possibility of fraud. And it's where do you draw that line that you're trying to prevent fraud? I understand you say here, there's not much chance of that with respect to amendments. But what about notaries? Why is that a legitimate function?
well, I think it's because the petitions say on it that everybody's got to fill out this thing in the presence of the circulator, and they write in the number. So they ask the circulator to swear that happened. That's it.
But how is that requirement any different than the requirement that there be a serial number?
Well, because the requirement for the signatures to be invalid and that the things that the circulator swears to all go to the meat of the process. The Constitution itself has a lot of these things in it. The serial number that says number doesn't know anything. I mean, that's the.
Is that, we're limited to the record, but I am curious, what is the admonition on the petition? I don't remember seeing any of the petitions in the record.
Oh, there's.
Are they attached to the appendix?
Yeah, boy, there's a million of them in the appendix, and I think.
Is it, no, you,
Yeah, okay.
I understand that you want to.
Yeah, no, it
you
starts,
should give-
they all start off with the, notice, the description, blah, blah, and.
But is the admonition about don't sign this unless there's a serial number on that
No,
petition?
no, I don't.
Well, we'll look at the record. I don't want you to take your time. I thought maybe there was a quick answer to that. We'll take a look at the record on that point.
Mr. Reisner, I want to ask you sort of the flip side of the question I asked your opposing counsel. I asked her if she thought you guys had substantially complied. She said you had. The flip side of the question for you is, do you agree that your clients have not strictly complied with the statute?
Yeah, I say that, no, I do not agree, because I believe that that we have strictly complied, because as I've argued, I think that statute is directory and not mandatory. And so I believe that we have strictly complied with what we're required to comply with.
So you're saying that you've given all the compliance that the legislature would insist upon at this point?
Yes, and, you know, in both Forest and the city of Bisbee, this court noted that that particular statute does not say that if you don't follow everything in this statute, we throw your petitions out.
Let me ask you,
It doesn't say that.
isn't the additional requirement of the statute that any page that doesn't have a serial number be torn out and taken out of the pictures suggest that the legislature did not intend that to be merely directory, but instead intended it to be mandatory?
Well, okay, hit me again with that question.
Okay, and I don't have the statute numbers in front of me. The statutory provision we're talking about includes the requirement that whoever the elections officer is, remove the sheets not bearing the petition serial number in the lower right-hand corner of each side. Doesn't that suggest more than the serial numbers or directory, but actually whoever promulgated the statute thought that it was actually a mandatory requirement?
You know, the other parts of that same procedure have been held not to be necessarily mandatory. So I'm not sure what they meant, but I would say that in terms of invalidating petitions, the legislature does not have the authority to do that. So whether they intended or not, I doubt they did. It may suggest it, but I think it's not part, it would not be part of their authority in the Constitution that they have, because they can only supplement the people in the exercise of their referendum authority. Now, what happens after the clerk does that, I don't know, but it certainly doesn't supplement the people's right in any way.
Assuming for the sake of argument that however logical or well-intentioned the provision, or however poorly drafted or poorly thought out the serial number requirement was, that the legislature actually intended that it be there
Yeah.
to prevent fraud,
Yeah.
wouldn't that fall within the realm of what the legislature is authorized to do, however ineffectually it may have done it?
I don't think so. You know, I think the job of the courts and the job of the judges, you know, is that you are to look at the Constitution as the primary law. You are to interpret the Constitution as the people intended, just like you interpret some statutes as the legislature intended in an area where their intent controls. Maybe this is an area where the courts need to say, look, the Constitution, we agree historically, we agree that our role is to assist the people in the rights that they put in the Constitution, and the legislature's ability is to help the people exercising their constitutional rights. And if we could parse something that says, maybe the legislature intended this thing, maybe they did, maybe they didn't, they don't have the right to interfere with the people. They have the right to supplement and assist when it helps. And what you do in a lot of these cases is you cut them some slack. You say, okay, you know, this thing actually relates to something that's important. It relates to whether these are real voters that signed. It relates to whether it was explained to them and their signature of the people who are exercising the people's rights. It relates to whether they understood it or whether it was fairly presented to them. So I think that's, As I see it, that's the goal. And this thing doesn't help. There's nobody who saw this petition. There's nobody that said, I'm gonna sign, and here's what the issue is. I live in Oro Valley, and gosh darn, this is the right serial number. It's entirely 100% unrelated at all to the process of the citizens saying, we want to exercise our right and challenge this law. To me, it's hard to imagine much benefit to the clerk's office, but whether there is any benefit there to utilize this to prevent the 3,160 people, the 27.5% of the people that sign these things. There's no reason to do that. You would not be carrying out your responsibilities to protect the people's right to referendum if you chose that course.
Thank you, Counsel.
Thank you.
Court takes this matter under advisement. This hearing is now concluded.
Chuck Aubrey here with Bill Reisner for Audit AZ News. You've just spoken with the appellate court and delivered your arguments. How do you feel about what you brought across? Do you think you managed to make your points?
Well, I thought the questions of the judges were good, and I like the panel, and I like I like our issues, so I feel pretty confident, but I'm not the guy that makes the decision, but I did like the questions.
One of the main points of contention seemed to be whether or not the serial number was mandatory or was the term discretionary?
I use the term directory.
Directory.
Yeah, that's what I think it is. So there's a bunch of stuff where the legislatures will say shall, but they don't mean, and they mean you should do that. We want you to do that. But it doesn't mean if you don't do that, you lose.
So,
and that's what I think this is, because of the importance of referendum, to have a serial number and say if that serial number's on, even though you've got all the signatures, people understand what the issues, they sign everything, you lose because of that. That's a technical defect that shouldn't stand.
So basically what you're saying is a technical defect shouldn't invalidate the will of the people in terms of referendum.
Absolutely. Absolutely.
Chuck Aubrey, Audit AZ News.